I would like to begin by acknowledging the traditional custodians of this land on which we meet, the Gadigal people of the Eora Nation. I pay my respects to their elders, past, present and emerging, and extend that respect to any Aboriginal or Torres Strait Islander people here with us tonight. My name is Anne Yang and I'm the Executive Editor of the University of New South Wales Law Journal. It's my privilege here to welcome you tonight. The first launch of the year is always a particularly special one, and we're delighted to be here at Herbert Smith Freehills for another packed house. I'd like to begin by thanking Herbert Smith Freehills sincerely, our host for tonight and premier sponsor of the journal. As one of the journal's longest running sponsorships, the relationship with Herbert Smith Freehills is immensely valued, and we are reaching a milestone of 37 years in 2019. We're immensely appreciative of the firm's long-running support of the journal over so many decades. Particular thanks go to Nikki Smythe and Rachel Koch, without whom tonight could not be possible. I would like to also thank Allens and Kingwood Mallisons, the journal's other premier sponsors, for their continuing support of the journal. As a journal run entirely by a voluntary student board, thanks must also go to our editorial board. We're also very grateful to the Dean of the Law Faculty at UNSW, Professor George Williams, for being with us this evening. And we'd also like to thank the journal's faculty advisors, Professors Rosalind Dixon and Gary Edmond. Your generous support and guidance are invaluable. Last but not least, thanks to Eloise Kneebone, the issue editor of issue 42.1. Over the past 12 months, Eloise has been responsible for receiving submissions, coordinating peer review, and managing the editorial process. The issue before you is a culmination of many hours of hard work over late nights, early mornings, and many, many cups of coffee, I imagine. Realising an issue is not an easy task, and Eloise has risen to the challenge with immense grace and enthusiasm, and it's been a delight to work with you. I'm going to keep it short and sweet and just hand over to Nikki Smythe now, a partner at Herbert Smith Freehills, who specialises in special situations lending, distressed debt, and structured finance. Thank you, Nikki.
Thank you. Good evening, everyone. I'm extremely heartened to see such a full room. I was just saying before that I remember my days as a member of the UNSW Law Editorial Board, and I don't think our launch has got quite the crowd that this one has, so that's really fantastic to see. My name's Nikki Smythe. I'm a partner here at Herbert Smith Freehills, and it's my great pleasure to welcome you all here this evening for the launch of Volume 42, Issue 1 of the UNSW Law Journal. I would also like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to the elders, both past and present. On behalf of Herbert Smith Freehills, I'd just like to say how thrilled we are to have you all here tonight and to be a premier sponsor of the UNSW Law Journal. And I was quite amazed to hear that it's been 37 years, which is really quite fantastic. The UNSW Law Journal is a fantastic publication with a consistently high quality of articles from the best thinkers and practitioners of the legal community here in Australia. On a personal level, I am very pleased to be here to introduce this event, being both a former student of the UNSW Law School and also, as I said before, a member of the UNSW Law Journal editorial board in 2003 and 2004, and I have extremely fond memories of being part of that and definitely understand the amount of work that's involved in putting together an issue. So I know you're probably all very keen to hear about the issues, so without further ado, I invite Eloise Kneebone, the editor of issue 42.1, to come up and introduce it, and also to introduce our esteemed keynote speaker, the Honourable Justice Michelle Gordon.
Thank you very much, Nikki. Before I start, I too would like to acknowledge the traditional custodians of the land we are on, the Gadigal people of the Eora Nation. I'd like to pay my respects to the elders past and present and acknowledge that this land was stolen and never ceded. Good evening, Justice Gordon, Professor Williams and all of our honourable guests tonight. Thank you all for coming. It's very, very exciting to have such a large turnout for a journal launch, which I am sure is in no small part due to the incredible keynote speaker we have tonight. I won't keep you all from hearing from Justice Gordon for too long, but before I introduce Her Honour, it's my pleasure to take a quick moment to celebrate all the articles that have been published in this issue of the Law Journal and to thank everyone who has made the launch of this issue possible. There are 12 amazing articles in issue 42.1. Launching these articles feels a little bit like being a proud parent on graduation day, and I'm so excited about the contributions that all these articles make to legal scholarship. Thank you to all the authors for entrusting the UNSW Law Journal with the editing and publication of your articles, and it's so wonderful to see so many of you in the audience tonight. I know a lot of you may have already picked up a copy of the issue. I see a lot of them are gone, and if you haven't already, I highly recommend that you do. But to briefly whet your appetite for what's inside, I want to just quickly run through all the amazing articles that are inside the covers. We, of course, have a lead article written by Justice Gordon, which I'll introduce later in my speech. In addition to this, we have a beautifully written piece by Christy Clark and John Page, which uses the recent High Court decision in Brown and Tasmania to explore the laws relating to public access to the forest. Stephen Clibben's article reports on employment standards for vulnerable temporary migrant workers in Australia. The theme of vulnerable workers is also addressed in Joanna Howe, Sarah Charlesworth and Deborah Brennan's article, which examines migration pathways for temporary migrant workers in Australia and New Zealand. We also have a piece by Anne Kayas-Kumar, who reflects on the importance of lawyers in international tax policy design and development. Camilla Pondle examines the legitimacy of the Australian Financial Complaints Authority, and Scott Donald and Suzanne Lemire report on a series of interviews with superannuation fund directors regarding director independence. In the Law Journal favourite topic area of constitutional law, Jonathan Crowe introduces the narrative model of constitutional implications to explain the High Court's recent decision in Roach and Electoral Commissioner. And we have Jessica Lake looking at the gendered nature of privacy laws, Mirko Bagarik examining the circumstances when family hardship should mitigate sentence severity, Alice Taylor analysing the purposes of Australian anti-discrimination law, and Denise Mason asking the question, what is a court of law? A lot of work went on behind the scenes to ensure that all these articles made it to print, and I'd like to take a moment to express my gratitude for everyone who was involved. As Anne said, we are eternally grateful to all of our premier sponsors, King & Wood Mallisons, Allens and Herbert Smith Freehills. The support of our sponsors is vital for enabling the publication of so many high quality articles year after year. It's particularly special to me to launch this issue at Herbert Smith Freehills, which has some of the best nibbles, I reckon, but also is where I completed my summer clerkship and I'll be back as a grad student. So thank you very much for having us, Freehills. The Journal is very proud of the fact that it's a student-run publication, one of the few entirely student-run journals in Australia, and a very well-respected one at that. This would not be possible without the support of the UNSW Law faculty, and especially the support of our Dean, Professor George Williams. I'd also like to give my sincerest thanks to the Journal's faculty advisors, Professors Rosalind Dixon and Gary Edman, whose formidable intellect and thoughtful advice were a source of immense comfort throughout my time as issue editor. As a student-run journal, we of course rely heavily on the student editors of the journal. Our editors are some of the most high-achieving students at UNSW and put an immense amount of effort into dotting every I, crossing every T, and questioning whether that use of a semicolon was really necessary. A sincere thank you to each and every one of the journal's editors. Your time, patience, and good humour whilst editing has been greatly appreciated. I'd also like to take a moment to thank the rest of the executive team of the journal. The 2019 executive team is made up of a group of incredibly strong, intelligent, driven women, and Nick, Thank you all for your support, guidance and generosity throughout the year. It's been a real privilege to work so closely with many people that have also become such close friends. I'd like to particularly thank the two executive editors that I've been lucky enough to work with, Lockie and Anne, whose guidance and leadership has taken the journal from strength to strength. And a special thanks also to Nick for taking that joke, and who has also been here for almost all my time, my journey as issue editor. I can't wait for your launch too. As you might have guessed, I'm particularly proud of the fact that 6 out of 7 of the 2019 Journal executive are women. It was almost the exact opposite gender ratio when I joined the Law Journal, and it's been great to see so many exceptional women in leadership positions in the Journal. This executive has also focused on improving the diversity on the Journal, especially engaging more with Indigenous students. I'm confident and hopeful that the Law Journal will become even more inclusive to ensure that all the highest achieving and most hardworking students can be a part of it, regardless of their background. And on a personal note, I'd also like to thank my friends and family. It means the world that you're all here with me tonight, and I'm endlessly grateful for having such fiercely supportive, caring and loving people in my life. And now, without any further ado, I'd like to introduce our keynote speaker for this evening. As I'm sure you all know, we are very privileged to have Justice Michelle Gordon from the High Court of Australia provide the keynote speech tonight. Justice Gordon has been on the High Court since 2015, prior to which she was a judge on the Federal Court, and before that a preeminent barrister. Justice Gordon wrote an article for issue 42.1 entitled Analogical Reasoning by Reference to Statute, What is the Judicial Function? And has generously given up her time to speak to us on the same topic tonight. Would you all please welcome Justice Gordon?
Thank you, Eloise, and thank you for the invitation to speak. I am, understated to say, delighted to be included in this issue of the Journal, but also unbelievably honoured to be asked to launch this amazing issue and to be in such good company, despite the article about Brown and Tasmania. We all need to read, think and grow. And legal scholarship should, in my view, cause each of us to think critically and to think about issues, concepts and ideas that just might not otherwise come across our desk. The UNSW Law Journal regularly achieves those aims, and from my review of the current issue, it succeeded those aims. In the words of Immanuel Kant, who was not only modest but super smart across so many disciplines, he said this: all the interests of our reason, speculative as well as practical, combine in 3 questions. What can I know? What ought I to do? And what may I hope? And given the events of last week, those questions are unbelievably profound. I want to take a legal aspect to them tonight. Legal scholarship isn't often able to provide an answer to those questions, or at least pose issues for consideration in getting to an answer to those questions. And not as importantly, the questions posed by Kant cause any real thinker, in my view, to pause and reconsider how we approach an issue. The questions themselves challenge any real thinker to look outside what each of us knows. And in my view, each and every one of us must continue at every stage of our careers, whether we're lawyers, including the doctors up the back, whether a student, academic, practitioner or judge, to ask ourselves those questions posed by Kant. What can I know? What ought I do? And what may I hope? So to mark the occasion of the launch of this issue of the UNSW Law Journal, and in that spirit of inquiry, I'd like to say something about the article that I have the absolute joy of having included in this issue. The focus, as Eloise said, is on the relationship between statute law and the common law. If you can imagine a cartoon depicting common law and statute law as oil and water, and the second frame of the cartoon depicting when they converge a milky pond, then what does the third frame look like? Well, I suspect it's going to contain a group of judges sitting in a boat, each judge with their own oar, each pulling in a different direction, with the judge up the back of the boat yelling, "So where are we going?" Each of you can identify the judges in the boat, and each of you can identify who's the one up the back yelling, "So where are we going?" So I ask, where are we going? The relationship between common law and statute law is complex. The question of how the two spheres can and should interact is far from settled. So one question might be, how do we approach the issue in the first place? It's useful first, I think, to identify the differences between common law and statute law. Why? Well, we know that common law methodology relies on analogy and adaptation, applying to new combinations of circumstances those rules which we derive from legal principles and, of course, from precedent. And that idea of analogising indicates, I think, at least at some level, that there must be a conscious and presumably reasoned choice to adapt a rule in a particular way. But statutes are very different. They've been described as inherently formal. Why? Well, first of all, they take precedence over other forms of law. Second, they're formal in content, often not corresponding precisely to any underlying rationale. Third, they exclude contrary substantive reasons. And of course, they lend themselves to interpretive formality. So given those overwhelmingly, I think, formal attributes, one must ask, I think, well, when are statutes then relevant to common law reasoning? How and should those two spheres, common law and statute law, interact? In my article, I put forward two propositions about how you might develop the common law by analogy or reference to statute. First, that viewing the development of the common law through the lens of formal rules and substantive reasoning can sometimes assist in identifying the way the judiciary develops the common law by reference to statute. And second, using that same lens also assists, I think, in understanding the basis upon which the judiciary undertakes the same task. For me, the assertion that the judiciary on occasion develops the common law by analogy to statute, often you'll see it labelled the doctrine of analogy, is simply a statement of conclusion. A statement of conclusion that I think invites several further questions. Is analogical reasoning by reference to statute qualitatively different from the usual type of reasoning on which the common law depends? And from what authority is this mode of reasoning derived? Put in different terms, what is the judicial function? Or, for me, what is my function? I think you need to answer that question, four things might be considered. First, the judicial function is conventionally understood. Second, whether substantive as distinct from formal aspects of statute assist in explaining that judicial function. Third, to satisfy or deem the implications of federalism. And fourth and finally, the principle of coherence. And I want to make some very brief remarks, if I might, on each of them. Turning first to the judicial function as conventionally understood. The idea that a judge's function in relation to statute does not extend beyond interpretation is firmly ingrained. We know that legislation is the most or the more truly democratic form of lawmaking. And we see in legislation what has been described as the more direct and accurate expression of the general will of the people. Put bluntly, legislators make the laws, and judges like me apply them. And that's the limit of my judicial function. Altering or rewriting statute is the function of the Parliament, not a Chapter 3 court, or for that matter, any other court. And any encroachment by the judges into the legislative sphere is constitutionally impermissible and democratically unpalatable. But stop and think about our role in relation to statute. In stark contrast to statute, part of the judicial function with respect to the common law is the opposite. It's to develop the common law. Indeed, the common law must be developed in order to meet the demands which changing conceptions of justice and convenience require. So, to identify that there exists a judicial imperative to develop the common law, of course, is not to suggest that the judges can alter the common law whenever we feel like doing so. As we know, common law judicial function has no operation except within some very constrained limits. The context of a legal dispute which has been initiated by somebody else, and then only within the constraints of the common law judicial method. And it's these differences between the judicial function with respect to statute on the one hand and the common law on the other that raise very interesting questions about when statute law may be deployed in common law reasoning. For example, do the formal characteristics of statutes that I've mentioned mean that statutes cannot be a source for the development of the common law? How can the judiciary rationalise reasoning by reference to statute within the necessarily constrained common law judicial method? Or, in less theoretical terms that I can understand, when can we as judges use statute to develop a common law? How can the judiciary use statute to do so? And more importantly, why should we do so? My thesis rests on the proposition that when statutes are limited or confined to what I'll describe as their literal or formal terms, judges do not develop the common law by reference to statute. It just doesn't occur. What do I mean by the literal and formal terms? Attia and Summers gave a very good example of a formal rule where a statute prohibits the driving of vehicles in a park. John decides to drive his car through the park. Why? Because he needs to take a shortcut so he's not late for an important meeting. Put bluntly, John's got a substantive reason for driving through the park. But as a judge, I've got no cause to take account of that substantive reason. And nor does the formal aspect of the statute, the prohibition itself, appear to me to offer any principle through which the common law might be developed. I, for example, as a judge, couldn't apply the prohibition to new circumstances not envisaged by the statute. Why? Because as I said earlier, the judicial function in relation to statute is very limited. We can't rewrite legislation, even if sometimes we would desperately like to do so. My thesis is that whilst those formal aspects of statute don't assist in the development of common law, on the other hand, the substantive aspects of statute can, and in some circumstances must, provide principles through which we do develop common law. And my contention is that this process can be distinguished from the application of the principle of coherence, which I'll come to at the end. Analogical reasoning by reference to statute can be viewed as one bridge, and I accept there are many others, between the separate but overlapping spheres of statute and the common law, and that's why it's so interesting. So far, so good. You may be curious then why, given the differences in judicial function with respect to both spheres, we as judges will be willing to extract principles from substantive aspects of statute when we develop the common law. There are, I think, multiple answers to that question. One response is that given the contemporary proliferation of statutes, we can't ignore them. A second, and I think perhaps more persuasive reason, is that there is no reason why principles in statutes can't be used by common law judges. It cannot be said, in light of the modern approach to statutory construction, for example, that statutes are devoid of principle and are merely enacted rules. Put in more colloquial terms, statutes often articulate legal principles, and those principles often reflect modern social and commercial legal values identified by the legislature well ahead of the courts. And third, of course, some statutes deploy common law principles. The often cited example is the High Court decision in Peters and Petersville, where the court used the phrase restraint of trade in section 45 as incorporating the changing standards of the common law. But there is no reason, in my view, that there should be one-way traffic, that statutory principles cannot, where appropriate, influence the development of the common law. And there are many cases, some of those that I analyse in the article, that reflect the traffic can and does go both ways. So why focus on judicial method in the interaction between statute law and common law? Well, to put it bluntly, judges differ as to the extent to which they consider statutes should be confined to the literal and formal terms, and differ in their willingness to identify and use principles in statutes to develop the common law. And whilst the substantive aspects of statute can and do provide principles through which the common law might be developed, that development is, of course, contingent on judicial willingness to consider that task and undertake that exercise. My thesis is that substantive aspects of statute cannot only assist in the development of the common law, but, as I illustrate in the article by reference to a number of authorities, explain when judicial function uses statute to develop the common law. Of course, I don't suggest that substantive aspects are always going to provide an answer. They clearly do not. There are, I think, three principles, not some of which are not always present, but if combined either together or at least in sequence, illustrate an area where there is often the development of the kind I've talked about. First, there must be a discernible principle in the statute. Second, the flip side is that where legislation is subject to frequent revision, it's usually not possible to identify a principle capable of being used to develop the common law. Put in blunt terms, the common law can't wax or wane according to the state of the legislation. The third influential factor in Australia are federal considerations. They impose a systemic constraint on the extent to which I think judges will use statute to influence the development of the common law. What do I mean by that? Can I take one case which is dear to my heart? It's the High Court decision in SO Australia Resources and the Federal Commissioner of Taxation in 1999. The central issue in SO was the test for determining legal professional privilege. The test in the Commonwealth Uniform Evidence Act was and remains whether the communication was made or the document prepared for the dominant purpose of the lawyer providing legal advice or legal services. That test accorded with a common law test developed in England, New Zealand, Ireland, and most of the Canadian provinces. It was a test that had also been favoured by Chief Justice Barwick in his dissent in Grant and Downes as early as 1976. SO's contention before the High Court was that by analogy or derivation, the High Court should develop the common law and treat it as being modified to accord with the statutory test, at least in those jurisdictions where the Uniform Evidence Act applied. In other words, they would ditch the sole purpose test, have it jettisoned, in favour of the dominant purpose test that was in place in the Commonwealth Uniform Evidence Act. They wanted the common law developed by using the Commonwealth Evidence Act to overcome the earlier common law decision in Grant and Downes. What's interesting is that the plurality in SO didn't reject the idea that courts could do that they could reason by analogy, by reference to statute to develop the common law. And in fact, they set out a list of areas of the law where that had occurred. After the court had done so, it turned its mind to decisions from the United States, New Zealand and the United Kingdom where they had actually done that. So it all looked pretty good. But then I think, significantly, they cited Lord Diplock in Warnick, where his lordship said, and I quote, "Where over a period of years there can be discerned a steady trend in legislation which reflects the views of successive parliaments as to what the public interest demands in a particular field of law, development of common law in that part of the same field which has been left to it ought to proceed upon a parallel rather than a diverging course." Interesting concepts. Public interest demands in a particular field of law. Doesn't sound judicial, does it? And in a parallel rather than a diverging course. Put bluntly, that legislation could be used analogically was not doubted. But despite acknowledging that this could occur, they decided and declined not to use it as a tool. 3 reasons were given. First, that the Uniform Evidence Act did not address all of the circumstances in which claim for privilege might arise. As we all know, it's limited to adducing evidence, not absent trial evidence. Second, the appeal concerned a claim for privilege pre-trial and not a claim that certain evidence could or could not be adduced, so it failed on the facts. And third, at that time, the Uniform Evidence Act didn't apply throughout Australia. In my view, federalism, was the real reason the court rejected development of the common law by reference to the Uniform Evidence Act. The limited scope of the statute, applying only to adducing evidence, meant that it was inapplicable to the facts of the case, but more importantly, the only sense in which the statute could be relevant as a source of development was through the extraction of a test that, to pick up the words of Lord Diplock, reflected a balancing of the competing public interests at stake. But of course there, and here in ESO, the plurality weren't convinced. There was no consistent pattern of legislative policy. There was no steady trend in the legislation. ESO is important because it identifies that there are implications for judges of federalism in the doctrine of analogy. What are those implications? I think there are three. First, the process of analogical reasoning by reference to statute necessarily depends on the principles which the statute or statutes express. It depends upon you and me identifying and extracting substantive aspects of statute. Any other sort of reasoning which attempts to extend the application of the literal text of the statute, its formal attributes, is outside its intended field of operation, of course, is, I've said, impermissible. It's contrary to the judicial method and what I can do. But that focus on principle brings me to the second point. It means that it may well be appropriate to develop the common law in the context of a matter arising in one state or territory by reference to legislative provisions enacted in another state, territory, or by the Commonwealth. For example, it may be appropriate to develop the common law in the context of a case arising in New South Wales by reference, dare I say, to statute law in Victoria. This is not a new concept. In the United States, where use is made of legislative analogies within the federal system, there's no suggestion that can't occur. And third, notwithstanding it may be possible to reason by analogy to legislation within different states or territories or even within the Commonwealth, I don't think it will be possible to do so unless there's a consistent pattern of legislation. There needs to be a critical mass, and that's what was missing in ESO. Finally, can I say something about the principle of coherence? Where does it sit in amongst all of this? It's been said it's difficult to define coherence, and I think it is. So for present purposes, may I define it and use that term as the idea that the development of common law rules may be affected by a desire to maintain consistency with policies or principles reflected in legislation in one or more states, territories, or the Commonwealth. You might, I suggest, be tempted then to dismiss all of what I've just said as the judiciary striving to achieve coherence. I accept that the principle of coherence is related to the doctrine of analogy. I also accept that coherence provides a powerful argument for the analogical use of statute in the development of common law. But I do not think that the development of the common law by reference to statute can be explained solely by the principle of coherence. First, as has been said by people brighter than me, filling out a common law concept is not quite the same as developing the common law by analogy to a statute. For example, a principle of common law, such as breach of statutory duty, may be expanded by its application to a new statute. I'm not talking about that. Or the common law may raise a nice question of statutory construction, such as whether a contract rendered illegal by a statute was intended to be also rendered unenforceable at common law. The expansion of a pre-existing common law principle, whilst a form of development of common law, is in my view one way, but not the only way, to develop the principles. And second, in my view, the point that principle alone doesn't necessarily explain the development of the common law by reference to statute is supported by the fact that the judiciary develops the common law even when there's no issue of coherence at stake. Historically, for example, significant elements of the common law had their origin in statute, as a gloss on statute, or in response to statute. Coherence was not the basis for the development of the common law in various decisions that I discussed in the article. And development outside the principle of coherence occurs because judges have a responsibility, in my view, to develop the common law aside from the need to ensure coherence. The common law cannot remain static. Common law must respond to developments of the society in which it rules. And, for example, a previously understood principle of the common law often becomes ill-adapted to modern circumstances and needs change. Or it may emerge, as it has done, that the rationale of a particular cause of action rests on a dubious foundation in the case law. Or the approach of the common law may be shown to be based on wrong assumptions of historical fact. Just look at Wick. In short, considerations of coherence, while essential to maintaining a legal system free of internal contradictions, is not the only factor motivating the development of the common law by reference to statute. So where are we? Was the judge in the rear of the boat right to ask, where are we going? The question of how the common law should function in what has been called an age of statutes remains a difficult one, and it remains a question to which we still only have a very partial set of answers. For me, the doctrine of analogy is just one subset of that partial set of answers. But I do contend that viewing the development of the common law through the lens of formal rules and substantive reasoning assists in identifying the ways the judiciary engage with and develop the common law using statute, and using that lens assists in understanding a basis, not the basis, a basis upon which we might develop the common law using the statute. It causes each of us to stop and think about where we might look when seeking to develop the common law. It causes each of us to stop and look outside the square, and I suggest to stop and ask at least the first of the questions I posed earlier. What can I know, and where should I look to seek to find the answer if I wish to develop the common law? So would there be a fourth frame in the cartoon? And what would that fourth frame contain? One of my colleagues suggested it was a wave swamping the boat. I don't think that it is a wave swamping the boat, but I suggest it is a boat still afloat on murky waters and possibly pointed in the direction of a shed on the shore, the sign which reads something like "Boat brokers and repairers, sail and salvage you choose." I don't know, but I do know that the boat ride is far from over. Thank you for the privilege of allowing me to be in the first issue of this journal, and congratulations to each of the other authors, to the journal team, especially to Eloise, the editor, on producing another valuable and informative issue of the journal, which I have absolute joy to launch.
Well, thank you very much, Justice Gordon. My name is George Williams. I'm the Dean of the Law Faculty, and it's my job to give a brief vote of thanks. I'd like to begin by saying, as Dean, just how proud I am of this issue and of the students who have produced it. I'd like to say that I can claim credit that my academics have done the work, but this is a student-led initiative, and the quality of this year on year is truly remarkable, and this issue deserves to go with all of those great issues that have preceded it. The fact that we've got 12 articles, however many footnotes, who knows? But as an occasional author in the journal, I know how much the editors pour over every footnote, every single aspect of the articles, and the attention to detail is truly remarkable. And I know how many coffee-fueled evenings and mornings are involved in this, and I'm really proud, as I said, to be Dean of a faculty that's producing such a wonderful journal year on year, and to see the traditions being kept up so well. I'd also like to say how proud I am that we've got such a strong editorial team this year. The fact we've got 6 out of 7 being women is of course reflective of the tremendous strength of women within our faculty, though they're right also to call for diversity, and we do need men to step up to these leadership roles. We've got 62% of our law students are female, and of course our women are leading in many ways, but it's not just men, but as indeed the call has been made, we'd like to see particularly more Indigenous leaders step up to this journal as well. And the editorial team has put a call out. They've got affirmative measures to make sure that Indigenous students are properly represented in leading this journal, and certainly I'd encourage them to apply, as I know the editorial board is. And this is particularly poignant for us at the moment because this week on Friday night we're celebrating the graduation of our 100th Indigenous student from UNSW Law. There's no other law school in the country that's come anywhere close to that level of graduation of Aboriginal students. In fact, some years ago a study showed that at UNSW, amongst all of the law schools, we had over half of all Indigenous law students in the country. So we've now got to 100, but we frankly need to do much better than that, both here and around the country. And so making sure that our Indigenous students have the opportunity of these prestigious, important positions is another part of us offering a great legal education. I'd also like to offer my thanks to Herbert Smith Freehills, as others have done. Now, 37 years, I'd like to say that's older than I am, but that would be a lie. But that is a really remarkable partnership that we have had, and I'd like to thank Nikki as one of our alumni for being here tonight. It goes beyond that, of course, to our pro bono activities. There are so many areas that we worked with the HSF team in that field. And most recently, we just had a launch here a couple of weeks ago to launch the joint partnership we have with our China International Economic Business Law Initiative, CEBL, which Herbert Smith Freehills is sponsoring and is the key partner of, which is really our major initiative in making sure that we are the leading law school in the world when it comes to understanding trade issues between Australia, China and the United States. And we now have the largest team in any law school in the world outside China of Mandarin-speaking academics, let alone students, of course, and I know we have many in this room as well tonight. So thank you to the firm for the really strong partnership that we have been privileged to enjoy for a long time. But I'd like to conclude with, of course, the most important thanks, and that is to Justice Gordon for her great talk tonight. And I would say, like a really great talk, it has made me think. And that's why I like to come to these events, because I like to really reflect and think about the law, to think about it differently. And so as a humble constitutional lawyer, it was great to hear a perspective on the common law and statute. And of course, I couldn't but help think about where are we going in other contexts, and constitutional law is the one that really I was thinking about often. How, by analogy, do we reason in these areas for constitutional law? And as a barrister, for example, I appeared in the Longy case where I actually had to write the submissions dealing directly with these issues of how actually do we intersect the law of defamation in its common law and statutory guises with a constitutional imperative. And on that occasion, I think even though we had a unanimous judgment, somehow it still resembled the boat that Justice Gordon referred to. And as constitutional scholars, we're still asking these very large questions about what is the role of the judge when it comes to these constitutional imperatives. Is it just a statute? How is it different? Is it somewhat a hybrid of some of the things that the judge has talked about tonight? And so I'll go away, I think, still reflecting on those issues, and it gives me a new language, a new way of actually thinking about some of those constitutional dimensions to some of these old problems. And I thank the judge very much for that thoughtful and really fascinating speech. So I'll wrap up there. I'd like to say thank you everyone for coming. We've got one more short thanks before we finish, but it's been a great night, and on behalf of the Faculty of Law, it's been really a great pleasure to be here. Thank you, Justice Gordon.
Thank you, George. That brings the formal component of the evening to a close. Thank you again to Justice Gordon, Nikki Smythe and Professor Williams for being with us this evening. Please feel free to stay and grab another drink. Thank you.